Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Maybe the most exciting and dramatic part of a criminal trial is closing argument, because it affords the attorneys that last opportunity to argue facts and evidence and for people to draw reasonable inferences and that sort of thing from the evidence. However, it is also at this point in proceedings that a prosecutor has a duty to avoid being so devoted to winning the case that he stretches things beyond the breaking point. When a prosecutor lets his or her emotions get in the way of a cogent, fact-based, essentially solid argument on the evidence and strays into trying to win with emotion, that's where you get into trouble, and that's what the court's role is. The court is there to rein the lawyer back in. And it's important for a prosecutor to remember that the purpose of the oral argument is to essentially tie up everything for the jury. In Bertolotti versus the state, the Supreme Court of Florida told prosecutors that the proper exercise of closing argument is to review the evidence and explicate those inferences which may reasonably be drawn from the evidence. Conversely, it must not be used to inflame the minds and passions of the jurors so that their verdict reflects an emotional response to the crime or the defendant rather than the evidence. And then in Terry versus State, the Supreme Court said that the purpose of closing argument is to help the jury understand the issues by applying the evidence to the law. Thus, the purpose of closing argument is not served or disserved when comment upon irrelevant matters is permitted. And then in Tribune versus State, the Second District Court of Appeal stated that a prosecutor has a duty to refrain from making improper comments that may tend to affect the fairness and impartiality of the trial. The Fourth District Court of Appeal said it's the prosecutor's duty to be a fair, honorable, and just prosecutor. And of course, the rules of the Florida Bar provide that you can't make reference to any matter that the lawyer doesn't reasonably believe to be relevant and is not supported by admissible evidence. You can't assert personal knowledge. Those are just a few of the case law citations that talk about what happens in closing argument with a prosecutor. But there are a number of things that the prosecutor cannot do in closing argument. Let's talk about them. At the top of the list, the prosecutor can't comment on the defendant's right to remain silent. He can't say, well, we've not heard from the defendant in this case. That's against the rules. You can't make any reference to the right to remain silent. That's a constitutional right, and the courts try very hard to protect that. You can't make a personal attack on the defense counsel. That shyster over there is just, he's representing this guy because there's money in it. You can't do that. You have to be honest and upfront, and you just can't ever make a statement like that somebody would, take for the truth of the matter, that the counsel is, a bad guy. You can't call the defendant a liar. Now, you can question their view of the facts, and you can say, isn't it funny that the person couldn't remember what color of shirt he was wearing on that day, but he could tell you everything about where he was. You can call out inconsistencies, but you can't just come right out and say, that guy's a liar. You can't comment on their demeanor. That guy sat there and smirked through the whole case, because the jury will have seen that. What you can do is you can say, I know you watched the defendant during the course of the trial, and I know how you saw how the defendant reacted. That's something you can pay attention to. You can't bolster the credibility of police officers. In other words, you can't say that fine officer's been there with the police department for 20 years. He's never had a disciplinary issue. In fact, until this event occurred, he'd never had his gun out of his holster. Those kinds of bolstering are essentially designed to make you reject any attempt to impeach the credibility of that police officer. So you can't bolster the credibility of a police officer. You can't make an argument that it's time to send a message to the community that we're not going to tolerate fill in the blank. You can't make an appeal to sympathy or bias or prejudice or passion. You can't refer to the defendant as a criminal. Even if the guy is a convicted felon, you can't comment about when a defense witness was listed. You can't comment on the role of the jury, telling them, you're the last best chance for justice for Mrs. Doe over there. You can't curry favor with the jury. You can't be seen doing things that are, you can't in open court stand up and say, Judge, I noticed some of the jurors are shivering. Can we turn the temperature down? The best thing a prosecutor can do is stick to the facts. You can't talk about your personal belief. I personally believe this guy is guilty. That doesn't matter. You're not a witness. You're not an expert. You are the prosecutor, and you are supposed to be someone who is neutral. You're not supposed to have your personal beliefs anywhere in this case. Asking the jury to determine who is lying. Well, somebody has to be lying, and it's going to be up to you to figure out who the liar is. That goes back to the issue of calling the defendant a liar, because you couldn't be doing it by indirection any more than you can do it directly. References to witnesses that were not called. A lot of times the defense counsel will talk about a witness that they're going to call, and for whatever reason that witness doesn't come. In most cases, you can't talk about that witness not being called. You can't make any racial comments. So those are the rules, and I've gone through them in summary fashion because I want to show you a clip from a recent oral argument at the state Supreme Court in Florida.
And there was a guilt phase argument as well as, not in the trial court. In the briefs, we have also raised an argument as to guilt phase closing. This is the only fundamental argument that we had to reach for, basically, in the appeal. There was a multitude of objections, if you've read the trial. The argument was a sort of musing by the state attorney to the effect that premeditation under Florida law is an extremely broad concept, and that it's satisfied by slapping a mosquito instead of brushing it away because the intent is present during the act. That's what he said. The mosquito swatting analogy misstates the law.
Didn't the comment actually make it sound like that at least potentially sound, one of the aspects of the comment made it sound like the intent was actually formed during the act?
That is what he said, and that's a misstatement because the statute just refers to premeditation. The cases are legion that define what premeditation is and is not.
Well, isn't the law that it has to be the intention has to be formed prior to the act?
Absolutely.
But then it has to be present during the act.
Correct.
Okay.
This was cherry picking is what we object to. There's in the standard jury instruction on premeditation, there's 5 sentences. 4 of them emphasize that there's got to be premeditation before the act, and the 5th I think it's the 2nd of the 5 sentences says it's got to be present during the act. So just taking it in isolation is, we submit, misleading. Now, fundamental error this court holds has recently reaffirmed in the Ritchie and Smith cases cited in the brief that fundamental error can be found in 2 circumstances. First, where the verdict couldn't be reached without the aid of the error, and second, where the interest of justice would be served by correcting the error. I have to concede that we cannot meet the former. We can't meet the former. In a case of improper argument, it's going to be virtually impossible for us to meet that standard. That standard originated in jury instruction cases, when if the jury is directed away from a possible route they could have gone, then that's easy to reach a decision, or it's possible to reach a decision that the verdict couldn't have been reached without the aid of the error. But with closing argument, we just can't meet that standard because we can't crack the jurors' heads open. There's a rule against it. I submit the interest of justice would be served here because we know premeditation was disputed. We know the jury was interested in it.
Don't we also know that the instructions to the jury contain multiple instances of the legal instructions on what premeditation consists in? Like because of the number of different crimes here, it's like the jury was getting it multiple times, correctly stated by the judge. We know that
the instructions were correct, yes, Your Honor, and they were repeated.
And they were how many times? Maybe 4? Was it 4?
I can't remember. I think 3.
You may not be aware of it, but Markeith Lloyd, several years ago, was involved in a series of crimes in the Orlando area. And during the course of those crimes, he shot to death a young female Orlando police officer. And it was a very tragic end to that young, promising career. And being that it was a police officer, the prosecutors take that kind of thing very seriously. And as a result of that, the state sought the death penalty. And in the death penalty, they have an automatic appeal to the Supreme Court if the state imposes or if the jury imposes one. And so that's why the court is there. So you see what the problem is here. The state, apparently in its closing argument, made an errant statement of law, because premeditation can be formed only moments before you commit the act, but it can't be formed while your fist is swinging, so to speak. It has to be formed before you take the first attempt to swing. And the way that was phrased, according to the state there, or according to the judge, is it made it look like maybe you were forming the intent as it was happening, which is not a correct statement of law. When the judge started talking about the jury instructions and that the jury instructions had properly stated the law, what he's basically telling her is that any error on the part of the prosecutor is essentially harmless error, because the jury had several copies of the jury instruction and it had been read to them 3 times. So they put some emphasis on that jury instruction, and as a result, the jury knew what the standard was. And I believe the court is going to come down on the side of this being a case where they should not reverse the judgment of the court or take away the verdict of the jury, because the jury was properly instructed by the court. These kinds of cases can be very emotional. I think it's really interesting to listen to the way this advocate argued. I want to cut through just a snippet of it here, and tell me if you notice the same things I do.
Aggravator was weighty. Here, the connection is not as clear. That a prior felony, of course, can take place without 5 life sentences. Our position is that the state did rely impermissibly.
First of all, she's very nervous. She's talking very, very fast. She's using her hands like this, and it has what basically is pretty distracting if you get right down to it. And so I think it's really important when you look at these kinds of arguments that you appear calm and rational and you make your best argument and move on. Unfortunately, in death penalty cases, particularly those presented by the public appellate defender, they tend to throw everything up against the wall and just pray that something sticks. These people believe very, very passionately in stopping the state from executing their client. In my opinion, the court here is going to rule in favor of the state. So that's what I have for you today. It was just a short little segment that I picked up from this oral argument at the Florida Supreme Court. If you have any questions, drop them in the comments down below. And of course, you can always email me at the address above. And again, thank you for being here. Thank you for listening, and have a terrific day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.